Joining me now are Mary McCord, former acting assistant attorney general for national security in the Obama DOJ and current co-host of the Prosecuting Donald Trump podcast. Also with me is Katie Benner, New York Times reporter on the national desk. Katie, I was very struck by the language in Jack Smith's filing today, the way in which he presents the gravity of this case. And I wonder what you make of that, the urgency of that argument, in light of all the back and forth over this.
There are so many filings back and forth, you're right. But when you step back, in essence, what he's saying is we have to decide whether or not the American people get to see and hear the full hearing of the evidence, both that the prosecutors have and the defense has. They get to hear the arguments and a jury gets to decide, and we should know the answer before an election, before we decide who should be president of the United States. Now, again, the Trump team has tried to cast this as a political move. But what if they have great evidence?
Yeah.
What if they can exonerate him?
Exactly.
Shouldn't they be able to do that in a court of law through our system of due process before an election so he could be on the ballot without the shadow of a potential prosecution over him? What Jack Smith is saying is whether or not he wins, a decision should be made. A jury should be able to weigh in on this before voters make probably the most important decision they're going to make.
Yeah.
Which is who becomes president.
Exactly. And it's almost been like, in that way, Trump has really dominated the argument by suggesting expeditious processing is somehow partisan. But of course, it's about the American voters having all the information at hand. Mary, I wonder, we played the tape of Nixon and Jaworski. The parallels are eerie. Even the same language, do not rush to judgment in this case. That was the Nixon filing, Trump's filing, partisan rush to judgment. I mean, it's not a coincidence. And I wonder how much you think the specter of that case looms as the justices potentially take on this one, given the stakes at hand.
Well, I think what's significant about the Nixon case as well as the Steele seizure case is there good examples of when a case is significant enough and important enough, it is reason for the Supreme Court to do two things. One, to leapfrog the Court of Appeals and take a case directly from a district court decision. And secondly, to take a case on an expedited schedule. And in this case, I think what Jack Smith is saying is that even though in the ordinary course, cases come up to the Supreme Court after a legal issue has been percolating in the courts of appeals for some time, sometimes years, with different circuits potentially ruling in different ways, learning from each other, and eventually the Supreme Court will resolve an issue. But here, what Jack Smith is saying, this is not the kind of issue that's going to percolate out in the other circuit courts for years. This has importance now. This is an unprecedented situation. I mean, the Nixon case is good precedent for timing, but of course that was not about the trial of a former president. That was about a different trial where evidence that President Nixon did not want to be supplied for that trial, that's what he was trying to guard against. Here we're talking about an actual former president being charged with and tried for crimes allegedly committed while he was president. And what Jack Smith is saying is, there's no need, whatever we do, stopping in the Circuit Court of Appeals for a ruling, this court, the Supreme Court, is still going to need to answer that question. And so let's just get there now and do it quickly, even if it means that the Supreme Court were to say, former President Trump, you're immune from prosecution. Jack Smith is saying we need a resolution.
Yeah, I was struck by another piece of the filing, Katie, which is noted by the special counsel that even if the government were to win in the D.C. Circuit Court, the default rules give Trump 45 days to seek a rehearing en banc, which is the full panel of judges, and 90 days to seek cert. Do the math. 90 days is 3 months.
Yes.
The trial's supposed to start in 3 months.
Absolutely.
That has to create a real climate of concern inside the DOJ. Just the rules themselves push for a delay.
Of course, it creates concern inside of the Justice Department. But of course, as you can imagine, the Trump legal team has also seen those very same rules and counted those very same days. So you really are seeing Trump trying to run out the clock. Problematically, he has all but said this is what he's trying to do. So it's not a secret. I mean, it's why we're not trying to get into his head by saying that. I mean, it's truly the strategy that he's espoused. So, of course, that is a concern for the department, because the last thing anybody wants is, we're already looking at so much unprecedented activity. The last thing anybody wants is a situation where there's a trial that's happening as voters are voting, with a verdict that happens in that period of time between the voters electing somebody and that person taking office in January. If you think we're having some really dicey Supreme Court conversations now, I think it would
just wait till later. Well, and I would argue even a trial or a conviction that happens after the nominating process, right?
Absolutely.
Because then it becomes a deep state plot to derail the nominee of one of our two major political parties.
And that's the in the public interest argument, right? Let us have a slate of candidates that everybody can feel should be the slate of candidates before we start.
Mary, do you have spidey sense about what the Supreme Court may do? I mean, they have two potentially very hot potatoes in their lap. One is the 14th Amendment call made by the Colorado State Supreme Court. The other is the presidential immunity defense here. Do you think that one might help the justices rule on the other, which is to say, Roberts is very concerned about the legacy and the impression of this court in terms of the public, how the court sees this, how the public sees the high court as independent or not. And might they take up both cases and rule differently for Trump on each to show that they are neutral arbiters?
So I do think they will take up both cases, because both are really extremely important, right? One about actually getting to trial on criminal charges against a former president. The other about keeping a former president off of the ballot due to his disability if he's found to have engaged in insurrection, which is what the Colorado Supreme Court found. There's no question that if the U.S. Supreme Court were to affirm the Colorado Supreme Court, take that case and say, you're correct, Colorado Supreme Court, Donald Trump is not qualified to be president under the 14th Amendment, Section 3, so therefore he cannot be on the ballot, then that would obviate some of the rush, the need to get this criminal trial done before election, because he would be off the ballot. I don't see it playing out timing-wise, though, that way, and I also think that it's a tall hill to climb for the plaintiffs to win in the Supreme Court in the Colorado case. It's not impossible, of course, but there are 8 different legal conclusions that the Supreme Court would have to agree with that Colorado Supreme Court made. So I do think the court will take both of these. I don't think the justice will think, okay, let's give Trump a win in one and give him a loss in the other in order to retain their integrity. But I think they will look at each case on their merits. The arguments are very, very different in each one. And I do think that, at least that most of the judges will be trying really to rule based on the facts and the law and what they think is right under the Constitution, because both of these matters raise significant constitutional issues. But there's no question they're human beings. They have in mind their institutional integrity and the impact of their rulings in both cases on this election in 2024.
Yeah, they are human beings, which is, I think, the kindest thing you could say about some of the conservatives on that court right now. But that's just me.